everyone. I'm going to make this second video and focus on looking at the sample motion for summary judgment that I posted on Blackboard that I have for you here. I apologize in advance. I have a contractor at my house hammering doors, so if you hear noise in the background, sorry about that. Okay, so in the interest of time, I only have 15 minutes, so I'm going to move through this pretty quickly and efficiently. If you have the document in front of you, you will see that they are two documents, the motion for summary judgment and the memorandum of law in support of the motion for summary judgment. You'll also note a couple of differences that will not be in your copy. Number one, this is a federal case, so the caption looks different. The caption belongs to the federal case in the U.S. District Court of the District of Massachusetts with its own docket number. You will use the caption that was provided for you in the template document with the Commonwealth of Massachusetts at the top and Middlesex County as the court and also the proper docket number. Second, notice that this is a motion for partial summary judgment. Yours is not a motion for partial summary judgment. Yours is a motion for full summary judgment because we only have one claim, the claim for social host liability, and this case had two claims, negligence and loss of consortium. This moving party is only moving for summary judgment on the loss of consortium, so we call it a motion for partial summary judgment. Yours will say defendant's motion for summary judgment. And last but importantly, something that I mentioned on the prior video, you will write defendant pursuant to Mass Rule of Civil Procedure 56, not the federal rule, because we are moving in state court, not federal court. But otherwise, your opening paragraph of your motion for summary judgment can look awfully similar to this one. Just make sure that you change it so that it's the Mass Rule of Civil Procedure, and also down here where it says about the reason for moving for summary judgment, yours is not about loss of consortium, yours is about social host liability, and of course we're not talking about the government's argument, we're talking about the defendant's argument. But the format and structure of this paragraph is one that you can model and copy in yours. Just make sure you edit it so that it is pertaining to your client. Okay, but you can see how we got the motion for summary judgment onto one page. Last, I forgot to mention, do not include this certification here. This certification under LR 7.1, that is a local rule that is only for the federal court. We don't have it in state court. So again, just delete and omit this. Don't even put this in yours. What I want you to look at is the content of the paragraph and just what the document looks like. Okay, there's your motion for summary judgment. Now, obviously, the memorandum of law in support of motion for summary judgment is a lot longer. I'm not going to spend the video reading it to you, but first, I actually just want to scroll through so you can see the formatting of the document. Just like yours, you can see that the heading, the caption of the document is here, and if we scroll all the way down to the bottom, you will see the signature block as well. Your caption will be remaining the same from your motion document to your memorandum document. Of course, change the title, and yours will say defendant's motion, memorandum of law in support of motion for summary judgment, not partial summary judgment. And now I'm just going to scroll quickly through. Here's your introductory paragraph, just like I showed you on the template. Here is your facts section. I would prefer if you call yours statement of undisputed facts. I think that is a more accurate and better title. I'm just going to scroll through. There's the facts. Then after a couple of pages, we get to argument. So same structure for you. Argument, letter A. You can also do Roman numeral 1 if you prefer Roman numerals. Summary judgment standard. Now notice this one is, it looks like 2 paragraphs. Yours does not need to be this long. We'll talk about it next week. Also note this particular summary judgment standard paragraph cites First Circuit cases. Why does it cite First Circuit cases? This is a motion in a federal court, and so the mandatory law that's being cited is First Circuit Court of Appeals law. You should be citing Massachusetts Rule of Civil Procedure 56, not the federal rule. You should also be citing Massachusetts cases like Pedersen versus Time or other ones, not federal cases. But the structure here could look similar. Again, doesn't have to be this long. Letter B for you is going to be your argument section. Now I want you to see, and we'll get back to in a second, how the argument, the heading doesn't just say grant me summary judgment. It says Mrs. X's loss of consortium claim fails because she and Mr. X were not married on the date of the alleged injury. So the heading for your argument section actually becomes like your contention. So what does this mean for you? Your heading B could be something like Donnie Davis's claim, Peters's claim for social host liability fails because, and then fill it in, because Davis did not control the supply of alcohol and did not know or should not have known his guest was drunk. So you can use that heading as a contention, get your parties excited for reading your argument section. Okay, then I'm going to scroll down. Here's the argument section. It's long. Yours will not be this long. And then finally, we get to conclusion at the end, which is just one sentence. So again, you can model it. Yours can say, accordingly, for the reasons articulated above, Peters's loss of consortium claim should be dismissed as a matter of law. So you can say something similar to that and then put the signature block. So I hope you can see the structure of the memorandum of law. Begins with the introductory paragraph, goes on to the statement of undisputed facts, argument section, section A, section B, and then a conclusion. Okay, in our remaining less than 10 minutes here, I do want to just point out to you what we will talk about in class next week. Number one, look at the facts. Every sentence in this facts section has a citation after it to something in the record. The record is another word for saying all the evidence. Like, what is it all together? All the depositions, the documents, the answers to interrogatories, pictures, newspapers, whatever it is we have, we call that the record. So we're going to cite to the record and to the evidence. But notice how it also tells a story. It's just that after every single sentence is a citation, but it reads like a story. Plaintiff brings negligence and loss of consortium claim under the Federal Tort Claims Act. Complaint, paragraph 1. Remember, I showed you in the prior video how to cite a complaint. Specifically, Mr. X claims that on December 7th, etc., id, meaning referring to that same citation above. Complaint, paragraphs 9 and 27. Semicolon, also a citation to the deposition of X at pages 53 to 55. So notice that we don't just say, plaintiff's claim was about this medical malpractice issue. The moving party actually cites evidence in support of that. And then it goes on to discuss the complaint. And then here's the not funny part that happened during a real deposition when we learned that the parties were not married at the time of the injury. It says here, however, plaintiffs were not married on December 7, 2001, the date of the alleged injury. And you can see here they cite the deposition. They also cite the answers to interrogatories. And then the story goes on from there. So what I want you to have ready for us to discuss next week is just look at this facts section and notice that A, it's written like a story. The story is still here. But B, after every sentence is a citation. So when you are drafting your facts section, that you can start from using your facts section from your interoffice memo, make sure the citations are in there. The citations to the complaint, citations to the answers to interrogatories, citations to the deposition, and you should have a citation after every sentence. And that is because the court needs to decide summary judgment. And the court can't decide summary judgment based on just what the court thinks. The court needs to see the undisputed facts. And they see the undisputed facts because we give it to them in the form of citations. Okay. Part number 2 that I want you to look at for next week is the argument. Oops, I went a little too fast. Sorry. facts. Oh no, there's still the facts, still the facts, still the facts. And then you can see throughout citing to the deposition. We talked a little bit about the summary judgment standard. So I want to move on and talk about section number B. Now, you may not believe me, but I want you, as part of this, I want you to see that the IRAC structure is still here. It just got really, really long. And so two things. Number one, the IRAC structure is here. Number two, it's changed to be persuasive, so there's no more issue sentence. Now it's a contention sentence. And no, I guess there's no number three. Number three, you will see when the author of this motion for summary judgment, when they get down to the analysis part, issue, rule, analysis, conclusion, the analysis part is exactly what I described to you, which is you need the citations to the evidence in it. So let me show you where that is. The heading is now your contention sentence. So think about that. I want you to, if you need to, pause it and think about it. Mrs. X's loss of consortium claim fails because she and Mr. X were not married on the date of the alleged injury. Your contention is going to be something like Peter's claim fails because, and you're going to fill that in. That's your main contention. Keep in mind, you will have two contention paragraphs. This person has one long one. Don't worry about this first paragraph here. This first paragraph just reminds us that even though this case is in federal court, Massachusetts state law on tort law applies. So you can kind of just skip over this. You do not have a paragraph like this in yours. And now look what we jump to. We jump to the rule of law. Here's your contention, or your issue, so to speak. And then under Massachusetts law. That sounds like a rule of law statement, just like you will have under Massachusetts law, or, however you would state it. A claim for social host liability only exists if a defendant controlled the supply of alcohol. Remember, you're going to do two of these. And here is, and again, I'm not going to spend time reading it, but it's long. There is a long section here discussing the law of loss of consortium and marriage in Massachusetts. It actually goes all the way down until the bottom of page 9. So I'll let you read that on your own. Why does this author need such a long law section? Something we can talk about next week. But in order to win on this summary judgment motion, the moving party needed to show very clearly that Massachusetts law is black and white. You're either married or you're not married. There's no like, what if you're engaged? What if you're living together? What if you love each other but you don't believe in marriage? Massachusetts law is very clear. Married, you get loss of consortium claim. Not married, you don't get it. And so the author needed to make that legal point. And so that's why there's a long law section. But notice the transition here to analysis. In the instant case, remember we talked about those transition words. There's only one paragraph here, but notice that this entire analysis paragraph points out the facts, summarizes and points out the facts from the statement of undisputed facts to show that this author has a basis for summary judgment here, that the facts show this couple was not married on the date of the accident or the injury, and therefore, as a matter of law, they are not entitled to summary. They are entitled to summary judgment, and the claim goes away. So I know I went over that really quickly, and I love that you can pause and rewind this, but basically what I want to show you is in this long argument section B, there is a contention, what is formerly your issue sentence, sitting in the heading. Then you skip that paragraph about the law and get to the one that says under Massachusetts law. There's your rule of law section. It's long. It's a couple pages long. But then when that section is done, the author has moved on to analysis in the instant case. And this paragraph, we're back to citing the evidence again. All right, I'm already done with 15 minutes. Take a look at these documents. I look forward to discussing them with you in class next Tuesday. Have a good weekend, everyone.